welcome. I'm Alas Garjuk and you're watching Head to Head with UATV. A team of lawyers for the 24 captured Ukrainian sailors currently being held as prisoners of war in Moscow are completing the first package of documents necessary for submitting individual complaints to international institutions. To talk more about this and other lawsuits filed by Ukraine against Russia to the European Court of Human Rights, we are joined in the studio today by Lishchyna, Ukraine's Deputy Minister of Justice and Government Commissioner for European Court of Human Rights. Hello and thank you for being with us today, Mr. Lishchyna.
Hello.
So, on January 7th, Ukraine has submitted this request to the ECHR against Russia, claiming to recognize the arrest of Ukrainian sailors illegal. Are there any results as of now?
Well, as of now, yes, you're quite correct. Ukraine has filed their application in full on 7th of January. Quite recently, this week actually, we supplied translations into English of all the documents attached to this application. And we asked the court to provide Russia with a time limit for their reply, for their comments to our application. So far, the court has failed, has not has not set any deadline for Russia, but we are hoping that maybe next week we would have finally this deadline and see when Russia would respond, and then that would basically determine when the Strasbourg court would be ready to hear the case on the merits.
But then what would Ukraine expect after Russia would submit their documents? The court, we would expect a recommendation from ECHR for Russia to release the sailors, or we would expect the court hearing started?
Well, eventually, of course, we expect a judgment saying that holding of our sailors as ordinary prisoners is a violation of the European Convention of Human Rights. But first, the court would hold a hearing. Depending on Russia's position and the court's attitude, it might be a hearing on jurisdiction, or, as we hope, the hearing on the merits of the complaint. I would say that this case differs significantly from our other interstate cases in that it is much shorter, simpler, and concerns one particular issue of a violation. That is why I don't see any reasons why the court cannot consider this case in a breached procedure without special separate hearing on jurisdiction.
So we can expect that this process won't take too long to be completed?
Hopefully, yes.
Okay. Another thing, Ukrainian sailors recognize themselves as prisoners of war, and also on the last session of Parliamentary Assembly of the Council of Europe, there was this resolution adopted that was not directly saying that they are prisoners of war, but that was demanding Russia to treat the sailors in accordance with the Geneva Conventions. And we do know that according to the Geneva Conventions, they cannot be held captive, they cannot be tried in civil courts, they cannot be held in the same facilities as regular detainees, and their access to information or to phone calls, to communication cannot be limited. And, well, let's not even mention the food standards and living standards that should be the same as their soldiers of the captured country have. So there are many aspects that Russia repeatedly violates and doesn't really formally, it adheres to the Geneva Convention, but in reality doesn't. So can we push on this in the ECHR also, or ECHR cannot really base its sentence on the Geneva Convention?
Well, this is basically the point of our application, that the breach of of the provisions of Geneva Convention, the treatment of our sailors different from the standards provided for in this Geneva Convention also violates European Convention on Human Rights. That's the point why we filed this application in the first place. So our idea is to prove that continuing holding of Ukrainian sailors as ordinary prisoners constitutes a violation of Article 5, among others, of the European Convention of Human Rights. And accordingly, they should be released, they should be treated as prisoners of war, and eventually should be transferred to Ukraine.
Mm-hmm. Well, moreover, I would like to mention one interesting fact that I want to ask you about. According to Russian Constitution, Article 15, the international decrees where Russia is one of the signatories have a priority over the national legislation. This means that Russians breach their own constitution by being not adherent to the Geneva Convention that they recognized. So could we use this argument in the court as well?
There is no point of using this argument before the European Court of Human Rights, because basically European Court of Human Rights can interpret the Geneva Convention and its applicability on its own. However, it is a valid point in submissions which should be filed before the Russian courts. As far as I know, this point is being raised repeatedly by the lawyers of the Ukrainian sailors. However, the Russian courts and investigators basically they refuse to consider this issue at all, saying that international obligations are political matters and we are not capable of applying international instruments directly, which is, of course, basically wrong. And you are quite right that by not complying with Geneva Convention, Russian courts basically violate their own constitution.
Unconstitutional. I remember in one interview you said that the whole situation, the whole scandal and crisis that happened in the Kerch Strait is nonsense because no one should have attacked military vessels. Could you explain us what have you meant?
I meant that there are some very basic rules of how you act on seas. And this particular incident, it is so obviously wrong from the standpoint of international treaties regulating the passage of ships in Kerch Strait. It is in breach of bilateral agreement between Ukraine and Russia regarding Azov Sea and Kerch Strait, which specifically says that military vessels of both states can pass through Kerch Strait unhindered. It specifically, and even assuming that Russia for some reasons could regulate that, and it couldn't, but assuming that it could not still attack vessels because relevant international convention on the law of sea specifically prohibits from attacking foreign military vessels. In principle, and it isn't even given that they could be pushed from the territorial waters of the relevant state, which they entered unlawfully, if they entered unlawfully, which they didn't. But assuming that they did enter those waters unlawfully, and assuming that those waters were actually territorial waters of Russian Federation, which they were not, still Russia could only do one thing: it could push those vessels outside their waters. What they did absolutely opposite. They actually attacked them trying to stop them from leaving those territorial waters. So they were allowed to push them out, and by the way, it's not very obvious from the conventions that they actually could use force to do that, but assuming that they could. But instead, they actually tried to stop them from leaving and attacked them when they saw that they actually left those waters.
Well, let's just hope that this process in ECHR will not really take a long time, because as far as we know, the recent news are about Russia forcing 3 of our sailors to undergo this psychiatric examination. So I remember 3 injured soldiers couldn't get appropriate medical care, but 3, I don't know, are they the same ones or not the same, but 3 of our sailors, they will have to go through this psychiatric examination. I also would like to remember one of the latest interviews with you. You said that international law is generally about goodwill. There was no such thing as so-called super court that would solve all the issues, and there is no superiors that would force them to comply with such a court decision. But still, we do have this case in ECHR, so what value does it have, and what can force Putin to let the sailors go on parole?
Yes, it is true that there is no such thing as a super court, an international super court, which could consider all the matters. International courts like European Court of Human Rights, ICJ, International Court of Justice, they have their own jurisdiction, and they can accept cases provided that the countries agreed to allow those courts to consider those issues. It's a little bit like arbitration in civil matters, in civil cases. You can go there only if you previously agreed that certain issue could be raised before this arbitration or international court. So European Court of Human Rights is one of very few courts where both Russia and Ukraine are parties to, and both Russia and Ukraine agreed that the cases of certain kind of violation of human rights within their territory could be brought before this court. And both countries agreed that the person who can raise this complaint is, first of all, the individual who suffered violation, but also a foreign state, because that's what convention says. That is why it was one of the main venues from the very beginning, from 2014, which was used by Ukraine to raise various issues related to Russian aggression, where they resulted in violation of human rights. Another venue is ECJ, International Court of Justice, but not as a general court, which it can be, but only provided Russia agrees, but only with respect to 2 conventions, one regarding the financing of terrorism, another one regarding the rights of minorities, which are being used by Ukraine also to raise similar questions.
So as far as I understand, even if Russia doesn't really adhere to the international law, these court sentences in the international courts will help Ukraine to increase the pressure, because this will be the sentence and the decision of the international judiciary system.
Yes, Russia agreed to allow these courts to consider these particular matters. If we win on jurisdiction and then on merits, we would be able to receive a judgment which would be binding on the Russian Federation. Yes, the enforcement of this judgment is basically still a goodwill, but the level of pressure to enforce a judgment of an international court is tremendous for any state.
And the last question I would like to ask you about 2 other lawsuits, big lawsuits against the Russian Federation in the European Court. One of them is Ukraine against Russia regarding Crimea. Another one is also Ukraine against Russia regarding Donbass. They are about human rights violations in those territories. So you probably had an access to the documents from Ukrainian side, obviously, and from the Russian side as well. Could you please compare and tell us about the strength of the positions? And this would be the last thing that we would conclude on.
With respect to Crimea, I think that we have a strong position because Russia itself accepts that those little green men were their Russian soldiers, which basically means that they were soldiers which is called like boots on the ground confirmation that their soldiers were right there, that soldiers were blocking or helping civilians to block Ukrainian military and law enforcement forces, that Russian green men captured those Ukrainian military facilities which allowed them to control Crimea, which basically means that Russian state-controlled Crimea, exercised effective control over Crimea starting from 26
February
2014, which is very important because Russia does not accept this date. But otherwise, our position is strong, and the Russian response is basically about international relationship, international law, which European Court of Human Rights, they believe, applies wrongly, but basically they accept those facts. With respect to Donbass, of course, it's much harder to prove because Russia basically says that we are not there. Их там нет. And if they're not there, we need to prove that they are there, and we need to absorb all the evidence we can find and provide them to the court, showing that the Russian troops are there. And only if we prove that, we would be able to make the next step, showing that those violations are happening in Donbass are actually the Russian liability.
But we do have these prisoners exchanges when we do send Russian militants and mercenaries from Ukraine back to Russia, being exchanged on our Ukrainian prisoners there. And also there is evidence that there are even Russian passports, the passports of Russian citizens who were taking part in this war. Would it be enough to prove that Russians are present?
Well, I hope so. The problem is, well, Russia, of course, says that those who are being captured by Ukrainian military, they are not actually the Russian formal soldiers, but rather former soldiers who just resigned and went on their own volition to fight against Ukraine in Donbass. What we are trying to prove that A, this is not true, that actually they are current military personnel of the Russian Federation, and B, even if they actually did that, Russia still supported their infiltration and provided them with weaponry, and that is also a form of control over this territory. It is still a very tricky international law issue, which European Court would have to resolve, but I still think that we have a very strong position on that.
That's great. Well, let's see how the court processes will be unfolding. So far, I thank you for this valuable information that you provided us with, and thank you for being a guest today in our studio.
Thank you.
That was Ivan Lishchyna, Ukraine's Deputy Minister of Justice and Government Commissioner for European Court of Human Rights. Thank you for watching Head to Head. I'm Oles Gajuk. Goodbye.